Good morning, everyone. Welcome to Landmark Chambers' very prescient seminar on the Hillsborough Law Bill, Navigating New Duties and Public Law Implications. I'm particularly reminded of this having listened to a newsagent's podcast this morning, which was talking all about whether or not Peter Mandelson should or should not be investigated for misconduct in public office, something which under this bill will become a statutory offence as opposed to a common law offence. So we can all have a discussion later about what misconduct in public office means or does not mean, because it is a somewhat vague, the common law offence has often been considered to be quite vague. So there's lots of new things within this bill, lots of codification of matters which public bodies should have been doing anyway, but also potentially some new and fairly onerous obligations for a variety of public officials, which I think anyone who works in the public sector or for the public sector really needs to know about. We have an excellent lineup of speakers this morning, and I'm not including myself in that. I'm joined by my colleagues, Chris Jacobs, Natasha Jackson, and last but by no means least, Claudia Hyde, who are going to be discussing various aspects of the potential new duties and bill. A few housekeeping points. Everyone's microphones are automatically muted, so you don't need to adjust any of your settings. We very much welcome questions. As this is a bill which is still in progress, we're not going to promise that we can give you all the answers, but please submit them via the text section in the Q&A, which is either at the top or the bottom of your screen. If you'd like to remain anonymous, you can tick that box to remain anonymous. We're going to try and answer all the questions at the end of the presentations. The webinar will be recorded and you will be sent a recording shortly after the event concludes. And if your connection is lost at any point, please just jump back in and dial back in using the mechanism where you originally joined this morning. Now, we've got a lot to get through, so without any further ado, I pass over to my colleague, Claudia Hyde. Claudia has a very busy practice as a junior administrative and public lawyer. She's currently instructed on 2 national public inquiries and has been a contributor to the book, which in fact all of us who are speakers today have contributed to, Butler, Blundell and Mills, The Law of Human Rights, available in all good bookshops from LexisNexis. We're not going to tell you which chapters we've contributed to, just in case you've read them and you don't think they're any good. Claudia is also on the executive committee of the Human Rights Lawyers Association. So let's pass over to Claudia now, who's going to introduce the new bill and the obligations on public bodies. Thank you, Claudia. Okay.
There we go. I've unmuted myself. Great start. Thank you, everyone, very much for joining us. Before getting into the detail of the bill, and there is rather a lot there, and I can't promise that we'll be able to cover all of it in the space of this morning, I think it's worth quickly canvassing some of the backdrop to this this bill, partly because it is the backdrop that maketh the bill, so to speak. Now, everyone, I'm sure, on this call will be familiar in broad terms with the Hillsborough Stadium disaster and the very lengthy struggle for accountability and truth that families of the deceased and survivors have faced. The procedural background, in particular, is a fairly checkered one. An initial inquest did take place, but it was not until a second inquest that concluded in 2016 that it was determined that fans did not contribute to the disaster and were unlawfully killed. A series of other investigations of various types have taken place. One that I haven't mentioned here, actually, but is worth noting, is that a police misconduct investigation run by the IOPC has been running since 2012. and is yet to publish its final report. But a consistent theme that has run through these various processes, investigations, and so on, was criticism of how public bodies, and in particular those standing to face criticism, engaged with the investigations, as well as critically their outputs. And this criticism was crystallised in the report of Bishop James Jones in, I think, 2016, possibly earlier, which challenged in no uncertain terms what he described as the instinctive prioritisation of the reputation of an organisation over the citizens' right to expect people to be held to account for their actions. So this encapsulation of the criticisms of the various Hillsborough processes, taken together, of course, with the experiences of many participants in other public inquiries and inquests, has culminated in a perception that the public bodies engaging with these sorts of forums and investigations routinely will prioritise institutional reputation over openness, learning, and accountability. And it is against that backdrop that Labour's 2024 manifesto committed itself to a Hillsborough law. And you'll see the excerpt of the manifesto pledge there on the screen. It's worth noting as well that the bill, in its current guise, followed an earlier bill called the Public Authority Accountability Bill, which was introduced in 2017 as a private member's bill by Andy Burnham. And this never really got past a first reading in the Commons, owing to a combination of snap general election and a lack of governmental support. So the fact that so many years after the Hillsborough disaster, after so many setbacks in progressing this legislation, the fact that it is now likely to come onto the statute books, it is truly a testament to the hard work of the many survivors, bereaved, and their families, and campaigners, lawyers, and countless others who have been calling for this law for a very, very long time indeed. And I think it is worth bearing in mind that background when we come on to some of the broader questions about what this bill provides and how it is to be interpreted against that backdrop. So moving on to what the bill actually says. As Fiona said, that there is an awful lot in this bill, and what I'm necessarily limited to doing in the next 10 minutes or so is cantering through some of the key obligations. Right at the heart of the bill, and contained in Clause 2, is a new statutory duty of candour and assistance, and that provides that public authorities and public officials must at all times act with candour, transparency, and frankness in their dealings with inquiries and investigations. Now, this, of course, builds on the existing duty of candour in the context of judicial review, where public bodies are required to put all relevant material before the court and therefore to the other parties, famously described as requiring all cards to be face upwards on the table. And many of us who are judicial review practitioners will have spent an awful lot of time arguing about what that means. But here the bill goes further. This is not merely a target duty. It is a binding obligation, which, as we'll come on to discuss, potentially entails criminal consequences in breach. So it's very much intended to represent a sea change. Still on Clause 2, it's worth noting that the duty has both proactive and reactive elements. So public authorities and officials must notify a person leading an inquiry or investigation if they believe that their acts may be relevant, or if they hold information that is likely to be relevant. What's notable here is that it is something of a shift from the sort of passive disclosure on request model that tends to be in place in most inquiries and inquests. Generally, a participant will wait until the inquiry sends you a request for evidence, and then you'll panic about gathering together all that evidence, and then you'll argue with the inquiry about whether or not you've fulfilled their request. Now, the burden is very much on you as a public authority to actively assist and take steps in order to help identify those lines of inquiry. And that will have significant implications for how public authorities engage with those investigations moving forward. Still, on clause 2, because it is a meaty one, it's worth noting that responsibility does not stop at the organisational level. And what clause 2 sub 5 tells us is that the public official who is in charge of the authority must take all reasonable steps to secure compliance. So that places accountability and the responsibility for discharging the statutory obligations squarely on senior leadership. And that will mean that suitable policies, protocols, and so on will have to follow. The bill also makes clear that compliance must be expeditious and it must be carried out without favour to the authority's own position or the position of others. And that is really reflects the whole nub of the bill. Any delay, defensiveness, strategic obfuscation, and the like, designed to protect those institutional interests, is precisely what the bill is seeking to combat. And I expect it will be important when construing this legislation and how its requirements will work in any given instance to bear that particular background in mind and also interpret obligations with that in mind. Before we consider some of the new offences that are created by the bill, I want to briefly consider the definitions and what that means in terms of the bill's scope. So firstly, what is an inquiry or an investigation? Well, Clause 8 gives us the answer to this, and it clarifies that the new duties will apply to statutory and non-statutory public inquiries, local authority inquiries, inquests, and interestingly, essentially any other investigation that is specified in secondary legislation. So that means that while some types of investigation have been excluded at this stage, or rather not expressly included, the door remains open for them to be included at a later stage. So the bill has been criticised in some quarters for not including ombudsman investigations, for instance. But those regulation powers in Clause 8 are likely to mean that the definition gets expanded further. And I believe that there is ongoing discussion as to the timeframes for that secondary legislation and when it will come into effect already. Next, in terms of who is caught by the Act. So the duty bites on public authorities and public officials. Both of those are defined fairly broadly, and it mirrors very familiar public law concepts about exercising functions of a public nature, although it should be noted that courts, Parliament, and the devolved legislatures are all expressly excluded. Similarly, in terms of public officials, those include most obviously those who are working for a public authority or holding public office, but it also includes those who are acting, but only to the extent that they are acting in that capacity. There is a deliberate breadth there, kind of tempered by the proviso that the acts in question have to be done in that official capacity. And as I'll touch on later, when we come on to some of the issues of the offences the offences of being misleading I expect that there will be some difficulty faced by the courts in figuring out the extent to which a public official has been acting to the extent of their functions as an official when being misleading. And with that note, let's turn on to some of the offences. The first one worth noting in Clause 5 is the offence of failing to comply. Specifically, this is a new criminal offence of failing to comply with the duty of candour and assistance. And an offence is committed where a failure is intentional and positively aimed at impeding an inquiry, or where, in some cases, the person is reckless as to whether or not their failure will do so. The penalties range quite significantly from fine to 2 years imprisonment. But it's worth noting generally that this marks quite a significant sea change from existing accountability mechanisms and is clearly intended to have a real deterrent effect and to give the duty of candour some teeth. One of the more controversial aspects of the bill is found in Clause 5, along with Clause 11, which we'll look at shortly. And there is much to be said about the various evidential burdens that I expect will be faced by prosecutors seeking to bring any kind of prosecution under Clause 5. But I expect that we will be discussing that for many, many years to come. So turning on now to Clause 11 and the offence of misleading the public. And this is the final provision that I want to consider in some real detail. This is, I think, a very interesting one. It has quite widely, but not entirely accurately, been reported as criminalising lying in public office. And what Clause 11 tells us is that a public authority or official commits an offence if, in that capacity, they act with the intention of misleading the public or are reckless as to whether or not they do so. So that's our mens rea or mental element. And they know or ought to know that their act is seriously improper. So again, the focus here is on the culture and the behaviour of the authority or official. And it's clear that things like deliberate obfuscation, spin, or the manipulation of information are what Parliament intends to capture here. However, it is tempered somewhat because it applies only to acts that are seriously improper. And what Clause 11 tells us is that an act will only be seriously improper if it involves significant or repeated dishonesty in respect of matters of significant concern, causing or contributing to harms, and departing significantly from what is expected in the proper exercise of the person's functions. So it is a very, very high threshold indeed. It's clearly aimed at capturing very serious sorts of wrongdoing rather than honest mistakes, obviously, as well as fibs, you might say. And while there is a lot to say about Clause 11, there are two aspects I want to pick up on in particular. The first is the issue of dishonesty. That obviously involves a prior factual question as to whether what was said or done by the public official or authority in question was in fact false. And my expectation, which may well be wrong, is that this is likely to be interpreted with a fair bit of leniency by courts, because there will certainly be some very, very tricky areas where the element of dishonesty is not all that clear. So certain public health information, for instance, or circumstances where a politician seemingly espouses a conspiracy theory, although with a belief in its truth. It remains to be seen just how broadly this will be interpreted, because I imagine that courts will be quite willing to strike a balance between giving effect to Parliament's intention on the one hand, and not having a chilling effect on public discourse on the other. The second point of note is the requirement that for an act to be seriously improper by departing significantly from what is to be expected. And what I would expect here is that this is to be measured by reference to objective standards. So I would expect that courts, in considering whether or not an offence has been committed, will draw upon standards like those of the public law and common law, codes of conduct, learnings from ombudsman reports, and so on. But in any case, it will depend on the specific circumstances and what can be expected of that individual or body in those specific cases. Finally, it's worth just noting very briefly some of the bill's wider provisions. I've canvassed a couple of the juiciest ones here. Public authorities will now be under a statutory duty to promote and take steps to maintain high standards of ethical conduct by Clause 9. And supporting that, Clause 10 says that there will be a duty to have regard to guidance issued under this section in relation to ethical conduct. So we can expect much more guidance being provided to public bodies on things like discharging the duty of candour, which I expect will be helpful in all manner of different contexts. Further offences are being created in respect of the commission of seriously improper acts, including a breach of a duty to prevent death or serious injury, which I expect mirrors Article 2 operational duties. Controversially, this has extraterritorial application, and that, I think, has been noted with some concern in defence communities in particular. Finally, just to note, and I think this will be touched on more later, the bill also proposes to amend LASPO to extend public funding for family member representation at inquests. This is something that campaigners have been calling for a very, very long time in order to improve equality of arms and engagement and thoroughness of inquests generally. And it will be interesting to see what effect this has in terms of the robustness of things like prevention of future death reports, recommendations, and other outputs from inquests. Now, there is much more that can be said about these provisions and the bill as a whole. Hopefully that gives you an overview of some of the key provisions and some helpful food for thought. And I'll now hand over to Natasha.
Thanks very much, Claudia.
Sorry, I should probably say before Natasha starts that Natasha, because I forgot to introduce everybody properly at the beginning, so I shall do so now. So but Natasha's going to speak to us about how to act with candour, transparency and frankness in the context of the Act, but also more generally within the context of public law proceedings. Natasha has undertaken several cases about the scope of the duty in respect of Article 2. She is currently or has been instructed in at least two public inquiries, and also in her work as a special advocate has undertaken a number of work with a national security focus, which is something which is of particular interest given that the Act is now going to extend to the security services and their operation and work. So thank you very much, Natasha. Let's pass over to you, and apologies for not introducing you before.
That's quite all right. Thank you, Fiona, and thanks, Claudia, for that really helpful introduction. So as Fiona said, I'm going to be covering some aspects of litigating this new duty of candour, or this anticipated duty of candour. What I'm going to do is firstly give a bit of an overview about kind of what the duty of candour is, where we find it at the moment, and give a bit of an overview of how the common law duty of candour works at the moment. And then I'm going to talk a bit about how this new duty of candour that Claudia's outlined compares to what we understand as the common law duty of candour, and how that might play out in terms of its operation. But I'm mostly going to try and keep this talk very practical and give litigation tips that I think hopefully will give some sense of how this new duty might be used, principally in the inquiry and inquest setting. But obviously, as Claudia explained, the duty does seem to go a bit wider than that. And then finally, I'm just going to touch on some of the scope questions. So in relation to questions of privilege, PII, public interest immunity, and national security, because there are certain provisions within this bill that accommodate exceptions on those bases. So firstly, where does the duty of candour come from? So the duty of candour obviously isn't a new concept. It's not one that's been invented by this new bill, but I thought it would be helpful just to contextualise what it looks like by having a look and seeing where we have duty of candour already in public law and in public life more generally. So firstly, we have the Nolan principles, which are the 7 principles of public life, which you can see on the slide there. I'm not going to spend much time talking about these because I think Chris and Fiona might be touching upon them again. But I just wanted to include this in the background framework to the duty of candour, because even though the Nolan principles don't tend to stand as a sort of litigation objective, the idea of openness, of honesty, of integrity and so forth is very much baked into the understanding of how anyone who works in public office should be operating. So I just wanted to, as I say, include that as a background framework, that a lot of these principles are ones that have been floating around for a while. But the main place that we find the duty of candour and litigate the duty of candour is, of course, in the context of judicial review. Now, for 9 cases out of 10, and actually I think the court has even reflected this in the HM case, which I'm going to come on to in a second. In 9 times out of 10, the place to start to understand what the test of the duty of candour is will be the administrative court guide. And there's a really helpful summary of what the duty of candour means in that guide, which you can see there on the slide. But in short, it's that cards face upwards approach to litigation that Claudia explained, and it goes a bit further in the administrative court to make sure that requires that pleadings and evidence and so forth are clear, and it's put in terms that they must not be ambiguous or economical with the truth or contain spin. So that's quite a high threshold already within the administrative court. And that guidance that is included in the admin court guide is summarised from a number of key cases that have litigated the duty of candour. Again, I'm not going to go through these in huge amounts of detail. I'm sure many of you are more than familiar with the scope of the duty. But just some points to draw out. So the Quark fishing case is one of the seminal cases on judicial review, and it makes clear that it's a very high duty on public authority respondents, and that's respondents in general, not just central government, to assist the court with full and accurate explanations of all the facts that are relevant to the issue. In the Citizens UK case, which I think was quite an unfortunate and unique one in that it was between the High Court decision, it was a case relating to immigration and coming to the UK from France for people on a list, and in relation to whether they met the criteria or not. And between the High Court hearing and the Court of Appeal hearing, more information came to light, which was then put before the Court of Appeal, and the Court of Appeal wasn't super happy about the duty of candour operation in that case. And again, you can see there the duty not to mislead the court can occur by omission, for example, by the non-disclosure of a material document or fact, or by failing to identify the significance of a document or fact. So again, we get a new facet here that that the duty of candour can occur by mistake, by failing to look in the right places and failing to ask the right questions. I think it's also in the Citizens UK case that we have the quote about judicial review requiring the good, bad and the ugly to be disclosed. So again, it's not just material that assists your case that needs to come out. The HM case is one of the most important and more recent cases on the scope of the duty of candour, and that related to a Home Office policy on the seizure of mobile phones by people from people arriving in the UK by Home Office officials. And again, that case was one in which an unpublished policy was came to light essentially through the course of litigation after the court had been informed that that policy was no longer operating. And I think that case is important and useful for a number of reasons. It's well worth having a look at if the duty of candour is an issue in a case you're doing. But I think interestingly for our purposes, looking as we will in a second at the new statutory duty, I think Lord Justice Edis in that case stated that the purpose of the duty in judicial review is that it enables the court to adjudicate on issues involving the state without deciding facts or engaging in disclosure processes. And I think that's helpful again to draw out at this stage that in the common law judicial review context, the purpose of the duty of candour has kind of often sat next to a disclosure obligation in civil litigation, where because the purpose of judicial review is not typically to make findings of fact on the basis of vast disclosed amounts of information, it's in order to adjudicate on whether the state has acted lawfully. We ended up with a slightly different duty that sits aside from disclosure in fact-finding contexts. And as I'm going to say in a minute, it will be interesting to see how this duty plays out in the context of inquiries and investigations where actually often the intent is to make findings of facts. So that's just kind of one quote there from HM, but as I said, generally a very important case. And I'm not going to go through them, but there's a relatively recent judgment from Mr. Justice Fordham, the Police Superintendents Association, which distilled 10 principles on how the duty of candour, or candid disclosure as he frames it, operates. If you are acting on behalf of normally a claimant, but someone who's trying to compel information via the duty of candour, it's probably quite helpful to look at the framing in that case, because it's quite a kind of generous framing of how the duty should operate. So just a couple more quick points, again, because they feed into how this new duty might operate and how we might be litigating it. In the common law context, we obviously have pre-action and permission stages in judicial review. There's case law. The Anguilla case in particular emphasises that the duty of candour doesn't just start at the point that you're at the substantive litigation. It can start a lot sooner than that. And I think I put policy superintendents as police superintendents. And there's another case, terror services, which clarify that the duty can be engaged even from back at the pre-action stage. So something again to bear in mind if you're requesting information or if you are a public authority. It's not the case that you don't need to engage, obviously, until the claim is issued. But crucially, the duty and the extent of the duty is context sensitive. So what might be required for the duty of candour to be met at a permission stage or a pre-action stage will, generally speaking, be much less than is required at a later stage in the substantive hearing. And finally, again, given that we are slightly more focused on claimant type or parties to the inquiry type litigants who are kind of on the other side of the public authority for the purposes of this talk, just a reminder as well that obviously that in the common law context, the duty does apply to claimants as well as to public authorities. And so it's not just a one-sided process. Again, interesting to see how that sits in relation to this bill, which is obviously focused exclusively on public authorities. Just as a note as well, though, because even though this new proposed duty would certainly step outside what we're used to in the common law in terms of its application, there is some precedent in relation to the statutory duty of candour. I'm not going to talk about it at any length, but I just wanted to outline Regulation 20 of the Health and Social Care Regulations 2014, because the structure of this is actually really quite similar to what we're seeing in the Hillsborough Bill at the moment. So we start with a general duty, and you can see there on the slide, a duty to act in an open and transparent way with people in relation to the care and treatment provided to them. This operates in the care context, but it's that duty to act in an open and transparent way. And then we have the specific duty of candour, which arises when there's been a notifiable safety incident. And that includes a duty to notify, provide an account believed to be true and give certain information. So I think a notifiable safety incident can be, for example, a death in a care home, and that incident therefore triggers this notification duty. And again, the notification duty has similarity to the duty to notify that Claudia was outlining in relation to this bill. And then also a point of comparison is that it is a criminal offence to breach the specific duty of candour, so the second of those two duties that arises where a notifiable incident has taken place. A point of distinction, however, is that the maximum penalty is a fine rather than a long prison sentence. So we do have a bit of a divergence there. But I've included on the slide an example of what I think was the first prosecution under Regulation 20 by the Care Quality Commission. So feel free to check that out if it's of interest. It may well be in terms of interpreting this duty as it becomes established. Okay, so having outlined a bit about how the duty of candour operates, particularly in the context of judicial review, I think it's interesting to think about what this new duty that we're anticipating looks like in order to try and understand how we might be applying it and how we might be litigating it. And so obviously it's early days. The bill is still in formulation. It's already changed quite a lot in terms of its scope. But based on the current drafting of the bill, I think in terms of the formulation of what the duty of candour covers, looks like it's aiming to put a similar kind of spin on it to the common law formulation. So I think it looks at present as a general rule of thumb that if something would get caught by the duty of candour, in terms of the contents of that material or the information it contains under the common law in judicial review, then it looks like it's going to come under the Hillsborough duty of candour as well. But I think, you know, as Claudia has pointed out, this does seem to be a much more wide-ranging provision. It contains additional notification and procedure requirements. It potentially extends to a wider number of people. So I don't want this to be interpreted as me saying it's the same as the duty in common law. But I just mean in terms of the material that might be caught, it does seem like it's going along similar lines. So I would expect that potentially the common law and how the duty of candour operates is going to be a kind of guiding principle when we come to understand what the Hillsborough duty of candour would require. But I do think that it's important that we do remain quite mindful of the different contexts in which these two duties are operating, the common law and the potential Hillsborough duty of candour. Interestingly, as I said, if I went back a couple of slides, I referred to the Batman-Gallage case and how the context of context of the proceedings is important to guiding what the duty of candour requires. Well, I think that's a really key point here because we are dealing with quite different contexts. As I said, judicial review is generally not focused on fact-finding. That's been recognised by the courts. Inquiries obviously almost always are. And so while it might not mean that we interpret the test for what the duty of candour requires differently, it might mean that actually that relevance touchstone means that quite different information does become important to disclose to the inquiry, where that information might not actually be relevant to the issues in the judicial review proceedings. So I think that's worth really bearing in mind when applying the test. And also, obviously, if you're seeking information from a public authority and kind of potentially pushing those buttons and remembering that context is key. And then also, I think I showed some of the case law on when the duty of candour applies, and again in relation to that context question, to suggest that it's quite recognised in common law at the moment that actually the duty of candour might start earlier, but it doesn't necessarily mean that you have to provide the same amount of detail as you would further down the line. Obviously, there aren't permission stages, sorry, that's meant to say stage, not state, for inquiries and inquest in quite the same way. It will be interesting to see how procedurally this duty starts to apply, but it seems, again, on first blush that actually this duty might kick in a bit sooner in proceedings than we might expect in the judicial review context. So again, that's kind of a question to see how this plays out in application. Again, recognising the different contexts at play. So, as I said there at the bottom, it seems like the common law is quite a helpful place to start to understand how this duty might be litigated, and I would expect some parallel approaches. I'd be quite surprised if there aren't. But I do think that we should be anticipating that there will be specific Hillsborough law case law on how this duty applies in the inquiry context, in the inquest context, and in other contexts that this bill, if and when it becomes law, will operate in. So just some quite practical tips now. These are broadly drawn from judicial review. I should say just before we start though that in terms of actually practically litigating this duty, it's meant to operate in terms of inquiries and inquests according to the current framing of the statute. Just from a pure practical perspective, that would mean that my expectation would be that you'd be raising issues with the chair or with the coroner as your first port of call when it comes to policing the duty of candour. And that's kind of reflected in some of these points here, which I'll run through. I think an earlier iteration of the bill had provision for applications to be made first to the chair or the person leading the inquest or the inquiry or the court. It was during a much broader framing of the bill. That seems to have come out now, but that original framing had suggested that judicial review could be the means of enforcing the duty where it wasn't kind of effective or possible to do so through applying to the chair. That wording isn't in the provision anymore, but I would expect that probably that still is the practical reality of how this will play out. If you're concerned that the duty of candour hasn't been met, I would expect you'd first raise it with your chair or your coroner or the person leading the inquiry that you're dealing with. If that doesn't lead to a conclusion that you're satisfied with, it might mean that you then seek to enforce the duty through judicial review mechanisms. And then obviously Claudia's talked through the criminal sanctions. It might be that you seek a referral to prosecution or make that referral yourself. So I just thought that was helpful to set out because I spent a bit of time when we decided to do this webinar just trying to figure out how it looked, like what happens, who's meant to be policing the duty, how are you meant to litigate it in practice, and I think that's probably likely to be how it plays out. But given that I think in most cases you'll be starting to play out this new duty in the context of the inquiry and inquest itself, I thought it was helpful just to set out some points on how that might work. So firstly, and the first point there goes to identify that this does, as Claudia said, go further than the existing compulsion powers or request powers that are under the Inquiries Act and regulations in relation to statutory inquiries. And again, as Claudia explained, while the kind of existing regime generally requires the inquiry or the inquest to ask the right question and seek material, this duty now goes a lot further. But if you're litigating in that context, it doesn't necessarily mean that you know what is where. And you're not necessarily going to be able to push the right buttons if you don't have a good understanding of where information is held by the public authority that you're dealing with. So I think requesting kind of they're often called KIM statements or statements that outline where data is held, where material is held, who are the repositories and who are the data owners from a particular authority is often a helpful place to start to try and understand what there might be and where questions should be asked and where stones should be overturned. Obviously, I think Fiona's going to come back and talk more about how to engage with this duty as a public authority. But the flip side of that is very clear. Record keeping, having good policies on information management, knowing where your documents are is going to be important if you're kind of the public authority at the receiving end of these questions. I think a key takeaway from litigating this in the context of judicial review is that trying to get someone to put things on paper, getting signed witness statements from relevant officials, using agreed documents to try and get kind of signatures at the end of things that reflect what the state of play is in the public authority's understanding is a really helpful way of kind of boxing in what you understand the facts to be. And in the event that then something comes to light that's inconsistent with that, you've got a piece of paper that says, you know, this is actually what you said and signed was the case at a particular point in time. And why is your case different now? And how does that relate to whether you've been complying with your duties all along? I think that's a kind of practical technique that might now find more usage in inquiries. That's quite commonplace in JR. Obviously using the inquiry procedures themselves. I know Chris is going to talk more about how to litigate this in that context. So I'll leave that to Chris, but broadly, you know, case management directions, requesting hearings to deal with these issues and so forth is a quite sensible way of going about this procedurally. Just one point again to draw out, there are parallel mechanisms to secure information. So it might be that if you're seeking something that might get covered by the Freedom of Information Act or the Environmental Information Regulations, making requests under those frameworks is a sensible kind of parallel tack. It's also interesting, I think, how often you get slightly different information through litigating through judicial review or in other contexts, and also through the Freedom of Information and EIR mechanisms, because I think often they're different teams that deal with those requests. And so if you're trying to get information from a public authority, using different levers and kind of cross-comparing, and also identifying why there are any discrepancies and how that relates to compliance with the duty of candour is also quite a sensible tack to take. So I think those are kind of an overview of some practical tips. I've put more on the slide, so I'll let you come back in your own time. But I just wanted to very briefly touch on this point about carve-outs and exceptions. So first, there's currently in the bill a carve-out of sorts for security and intelligence information, in that the duty of candour does apply in the current drafting to the intelligence services, but the notification obligations, which Claudia outlined, the kind of specific duty, do not. Now, this is a source, for anyone who's been following this in the press will know, it's a source of some controversy at the moment. There's a big kind of debate within government and with the security community as to whether or not this duty should apply. I think I need to say no more at the moment than watch this space, because I think there's a fair chance that whatever we say about it now will be outdated, but it's just for awareness that that there is currently a modified duty in that context. But also, and I won't go into this in much detail, but just to note that the exceptions for privilege, so for legal professional privilege, litigation privilege, and also the privilege against self-incrimination, which is, I think, a very interesting topic, but not one that we can go through today in terms of its operation in this act, this bill. But there are carve-outs to protect privilege, and there's also a carve-out for public interest immunity applications. So the same kind of exemptions to providing information under the Inquiries Act are preserved in this new bill as exceptions to the duty of candour, and are extended so that even in non-statutory inquiries that aren't subject to the Inquiries Act, you still are not required to provide information if it comes under those provisions. So yeah, just one last tip for litigants. Again, this is not Hillsborough bill specific, but if you are facing a response from a public authority that material can't be disclosed because it comes under a privilege, that may well be the case, but if you have reason to question that, you're fully entitled to seek schedules, to ask for details about why those privileges are being called upon, and request to challenge or request judicial inspection if you're not comfortable with the answers that you've received. So that's a bit of a canter through some litigation tips. I will now pass back to Fiona in order to introduce Chris.
Hello, we now pass over to Chris. Chris has been involved in a large number of public inquiries over the past 10 years, I would say, including the independent inquiry into child sexual abuse, the Brook House inquiry, the Post Office inquiry, and the COVID inquiry. So he is well placed to understand how aspects of the bill will impact directly upon public inquiry and inquest practice. So I now pass over to Chris to talk to you about that particular topic. Thank you. We seem not to have Chris. Chris has obviously been given a compliance direction by the chair of the inquiry and has decided to absent himself extraterritorially. Let's just give it a couple of minutes. Chris, could you come online for us, please?
Hello, right. Can you see and hear me okay? Can you see and hear me? Great, all right. Sorry, literally the moment I was about to come on, my computer did something that it wasn't supposed to do, but that is the nature of these things. So moving back to the beginning of the slides. So if Emily, if I could ask you to go to that page there, and moving down, Emily, to the next page, please. Thank you. So the Public Office Accountability Bill deals with inquiries in numerous places. You can see there it's in the preamble. The duty relates to public authorities' dealings with inquiries and investigations. And the core duty is a duty on public authorities, in particular with reference to inquiries and investigations. And if you could move to the next page then, please. In relation to the duty, just waiting for the page to change. We seem to have a technical issue there. Thank you very much. In relation to the duties and powers aspect of the bill, Claudia touched on this. There is a mandatory duty on public authorities to notify the person leading the inquiry or investigation if that public authority or official has grounds to believe that they're actually irrelevant to the inquiry or investigation, or they otherwise have information likely to be material to the inquiry or investigation. The important word there is must. This is a mandatory duty that is imposed, and there is a discretionary duty on a person leading an investigation and inquiry chair to require a public authority or public official to provide information by giving an oral or written statement. The important point there is that a public authority, if it believes that their acts may have been relevant or they otherwise have information which is likely to be relevant, must provide information. They don't have to be directed to do so. So moving over to the page in relation to the duties and powers. So the duty of candour doesn't only apply to public bodies, it applies to individuals and to companies as well. So importantly, we have the word must again. A person who is not a public authority or public official, but had a relevant public responsibility in connection with an incident, must comply with the duty of candour and assistance in relation to an inquiry or investigation being held in connection with that incident. And the relevant public responsibilities are to do with health and safety, or if the individual or organisation is a service provided to a public authority and had a significant impact on members of the public. Now, that might be relevant for cases such as, or for inquiries such as the Grenfell Tower inquiry, if there ever is, if sadly there has to be another inquiry in relation to a similar incident, when you have individuals or companies concerned that are not public authorities. They are also compatible in relation to the duty of candour. And you can see at the bottom there, clause 5 imposes an offence. Claudia has dealt with that. So over the page then, talking about compliance directions, and having to speak for myself, I'm not happy to talk about them. Arguably, in my view, the most significant change that the bill introduces is this new power for an inquiry chair to make a compliance direction. And what's interesting about this is that this too is mandatory. If you look at small paragraph 1 down at the bottom of the page there, the bill proposes an amendment to the Inquiries Act, and after section 23 inserts a new section 23A, whereby as soon as reasonably practicable after the start of an inquiry, the chair of the inquiry must, subject to subsections that to do with regional autonomy and official secrets, which I'll come to later, but the inquiry chair must give a compliance direction to a public authority or a public official, or to a person who had a relevant public responsibility in connection with an incident to which the inquiry is concerned, if it appears to the chair that the person's acts may or may be relevant to the inquiry, or that they otherwise have information likely to be relevant. So it's an onerous duty on an inquiry chair to issue a compliance direction on any public authority or public official or individual who had a relevant public responsibility if those issues are likely to be engaged with regard to the inquiry. Moving over to the next page, Emily, please, if you could change the page, thank you. So a compliance direction, this is dealt with in the rest of the part of Schedule 1 is a direction to comply with the obligations of under the duty of candour or assistance. It's not limited to the start of the inquiry. An inquiry chair can issue a compliance direction at any time. The compliance direction must be given to a person who appears to be in charge of a public authority or who had public responsibility in connection with an incident to which the inquiry relates. Now, the importance of that is that this is imposing a duty and a liability on an individual, not just a huge faceless corporation like perhaps the post office is. You're directly going to an individual who is in charge, and it's that person's responsibility if the duty of candour is not complied with. So I think that's quite an important, a strong safeguard against public authorities' natural tendency to be defensive when receiving requests for disclosure or information. As we touched on, a compliance direction can't be used to require production of evidence that's subject to privilege or public interest immunity, and there are enforcement provisions. Section 35 and 36 of the Inquiries Act applies to compliance directions insofar as an offence would be committed if there's not compliance with the direction, and there are enforcement provisions in the High Court or the Court of Session. And then a person ceases to be subject to the duty of candour and assistance when the inquiry comes to an end. Now, moving on to the next page, please. In relation to the Official Secrets Act, and Natasha touched on the security services aspect of this, a compliance direction may not be given to a public official if it would require that official to provide information relating to security and intelligence within the meaning given by Section 1(9) of the Official Secrets Act 1989, and a public official is not required to provide such information. Now, I've put Section 1(9) there, and it's the work of or in support of the security and intelligence services or any part of them, and references to information relating to security and intelligence, and it includes information held or transmitted by those services. Now, that is controversial because it enables, because the definition in Section 1(9) is quite wide. Anything that's covered by the Official Secrets Act and that section is capable as not being disclosable after the issue of a compliance direction. I've referred to a BBC article. There have been many articles about this, and this provision could impact on public inquiries where the conduct of security agencies is under investigation. I've referenced the Finucane inquiry there. Patrick Finucane was an Irish lawyer who was murdered at home in front of his family in 1989, shot by by loyalist paramilitaries, and there have always been allegations that there was state collusion in his killing. There's going to be a public inquiry that's taking place later this year that's going to investigate that, and it is likely that the security agencies might say that they're not required to give evidence if this act is implemented by that time, because there are Official Secrets Act issues arising. In order to look at what the implications of compliance directions are going to be for public inquiry practitioners, we need to really compare what is going to be put in place with what is in place now, which is Section 21 of the Inquiries Act 2005. If we can move to the next slide, please, you will see that, just waiting for it to move along, the new power to issue compliance directions adds to the existing powers under Section 21, and that's really been the main means by which public inquiries compel parties to comply. For example, in the Post Office inquiry, the Post Office were pretty quite poor in complying with requests for disclosure. And on one occasion, a witness was about to give evidence, and at least 1,000 pages of documents were disclosed on the evening before he was due to give evidence. And the inquiry chair used Section 21 powers to compel the attendance of Post Office senior officials to give evidence, to explain why the disclosure process wasn't being complied with and had gone wrong as far as the Post Office were concerned. So Section 20, so that particular section is an important power. It enables a person, it enables the chair to issue a notice to require a person to attend, to give evidence, to provide a statement, or provide documents or anything in their custody that relates to an issue in the inquiry. There are exceptions in relation to privilege and public interest immunity, and there are the same offences for failing to comply, and the same enforcement provisions. So what we already have is, you know, a reasonably strong power to enable an inquiry chair to compel a court participant or any individual or institution to attend, to provide evidence, to give a witness statement, or provide disclosure, and there are good enforcement mechanisms in place. So I suppose we really need to ask ourselves, moving on to the next, very well preempted, Emily, to the next page, how will the compliance directions affect public inquiries? How will they change things? And there's the first point that we've touched on, that the measures could provide an exemption for members of the security services who are able to rely on the Official Secrets Act. There is also, as I've indicated, an overlap between the Section 21 powers and compliance direction powers. And it's right to say, certainly been my experience, that the Section 21 powers are generally effective. In my view, compliance directions are more likely to impact organisations at the pre-hearing disclosure stage, because Section 21 is really, it comes into play once the inquiry is underway. So an individual who is involved in an organisation, who probably has a great deal of corporate loyalty, we saw that in the Post Office inquiry, might be defensive, might not want to sort of put all the cards face up. But the fact that they can be forced to do so, and that there is a duty to do so, would give pause for thought. If an institution is going to decide to only sort of disclose on a limited basis, these provisions might lead to a more candid approach to disclosure, where perhaps there hasn't been so in the past. It might also prevent cover-ups right from the word go, because if an organisation knows it's doing something that it shouldn't be doing, and there could be, like in the Post Office case, an inquiry down the line, it's not going to fail to disclose material. It's not going to cover things up, because that could be exposed later through the compliance directions. It's also more likely that privilege will be waived, and it's right to say that the Post Office did that in the Post Office inquiry. Moving over the page, I think that the fact that the provisions focus on individuals, and it's not just a huge organisation that is responsible and bears the duty, that's more likely to lead to greater institutional accountability. And then there's this grey area between self-incrimination, findings, an inquiry can't rule on or determine a person's civil or criminal liability, but there's that tension between being required to disclose something that could render one liable, and there are in public inquiries now, we saw it in the Post Office, self-incrimination. A witness will be warned not to incriminate themselves before giving evidence, or in a material part of their evidence. So there is that tension there. Over the page then, participation of persons and inquiries in investigation. This was something that was touched on earlier. There will be more equality of arms. There is a requirement that public authorities engage legal representation to act for them at UK inquiries and investigations. In relation to public inquiries, that's not going to make a great change because most institutions are representative, they're core participants. But perhaps more significant are the clause 18 D and E provisions, where there is an overriding objective aiming at ensuring that affected persons are able to participate fully and effectively in the inquiry or inquest proceedings. And Claudia, I think, mentioned LASPO and the ability of legal aid to be made available to bereaved family members at inquests where a public authority is an interested person. So that's a real positive, that you're not going to be an individual complaining about institutional malpractice or abuse or a scandal and have to be concerned about not being legally represented. It's going to be easier to get representation in respect of those situations. So just to end, although it's not the subject of this talk, if we could change over to the next page, Emily, please. Non-statutory inquiries. What is particularly interesting and significant is that the compliance directions apply to non-statutory inquiries. And one of the features of a non-statutory the non-statutory process is that a non-statutory inquiry chair doesn't have the powers that a full statutory public inquiry chair will have. And the fact that now a non-statutory chair can issue compliance directions is a great step forward in ensuring that parties and participants cooperate in that process. And I put down there on the 15th of January 2026 in the Manston non-statutory inquiry, the chair, Sophie Cartwright KC, referred to the bill in her opening address at a preliminary hearing and said the inquiry inspects and encourages candour and transparency and frankness from all those material participants and providers. When the bill is enacted, if it is enacted, and of course there's a great big caveat because we don't know what form it's finally going to take, this expectation will become a requirement. And then very finally, over to the last page, in relation to inquests, the bill amends the Coroners and Justice Act 2009, Schedule 5, to introduce compliance directions for inquests. Well, that's all there is from me. I'll now pass back to Fiona. Bye.
Thank you very much. I'm dealing with parts of the bill which don't necessarily deal directly with issues, well, which are related to issues to do with duty of candour. But this bill does more than simply introduce or reintroduce or establish or strengthen issues to do with candour. It also provides for various other changes to the way that public bodies operate, or rather codifies what should have been going on anyway. Next slide, please, Emily. So I'm going to talk a little bit about those parts of the bill now. Firstly, there is going to be statutory enforcement of the Nolan principles for all public authorities. So a clause in the bill at the moment, and I can't imagine that this clause will change, is that all public bodies and public authorities will have to have a code of practice which will align with and set out the relevant Nolan principles. Now, everybody who works in public office at the moment should have the Nolan principles engraved on their heart, but all public authorities are going to have both promote these and adopt a code which sets out the standards. So whilst there is a code at the moment, the Civil Service Code has statutory effect under some legislation in 2013. Most other public authorities do not at the moment have a particular code of conduct, and that is going to be grounded in the principles which are selflessness, integrity, objectivity, accountability, openness, honesty, and leadership. And for those of you who work in local government, the current proposal really goes alongside suggested proposals to strengthening councillors' codes of conduct and to the reintroduction of a national board to deal with the conduct of councillors where they fall below the requisite standards, and a new national code of practice for councillors, which I think will be meshed into this the need. But it will go further than that, because don't forget, we're talking about all public authorities here. So that's going to include health bodies, social care bodies, education bodies, police forces. You're all going to have codes of conduct and adopt those codes of conduct. So there's going to be quite a lot of people drafting things over the next few years. What is likely to happen is the government has already said that it's going to issue a part and parcel of the bill will include issuing a code of conduct for the way that public bodies should approach inquiries. I suspect that there is likely to be a how to draft a code of conduct or a code of ethical practice. Now, most of the time, there is this material already in various places within public bodies, but it's going to be drawn together all in one place under clause 9 of the bill. And I can't see this particular clause changing. Next slide, please, because it's fairly uncontroversial in nature. So the question, however, is, given the wide nature of who may well be conducting factors on behalf of a public authority, you're going to need to think about, is it going to apply to private contractors who may well be undertaking public work? So, for example, you now have, particularly in local but also in central government, public services often being delivered by private contractors. That is them undertaking a public act or a public service. So you are going to have to get them to sign up, it seems to me, to the code of ethical conduct and to all the various matters. The next practical implication is baked into the procurement of those services, which are going to be considered to be public in nature. Next thing, although there is no doubt when people are first employed by public bodies, they will talk about the Nolan principles. Usually when you undertake interviews on behalf of public bodies or public officials, you talk about that. Often you have to sign a contract which says you will comply with the Nolan principles. For example, public officers, civil servants have to say that they will comply with the Civil Service Code, which includes those matters. Local authorities often say the same thing. But again, I think there's going to need to be wholesale refresher training on what the Nolan principles mean, and more importantly, how they operate in principle. Secondly, referrals where there's a belief that the code has been breached. You're going to be able to make protected disclosures to the public authority under the various whistleblowing protections that there are. So your whistleblowing lead's going to have to add this to the roster of matters that they're dealt with. And next, there is power under the bill for the matter not to apply to various public officials, but we'll wait to see when that happens. There's also under, as has been discussed, clause 4, extension of duty of candour for those with relevant public responsibilities, including obviously health and safety responsibilities and service providers to public authorities. And it also includes, interestingly, incidents which take place on the parliamentary estate. So even though Parliament itself is excluded, if there were to be a catastrophic health and safety incident, and as my understanding is the House of Commons is just one great big catastrophic health and safety incident waiting to happen. So if there were to be a fire at the House of Commons and there were to then be various discussions, then there would be an extension of duty of candour in any subsequent inquiry that were to take place. One of the reasons there is this is to address the issues which got raised in Grenfell, which was about various people who were private subcontractors providing but building public buildings would not necessarily have various sorts of responsibilities. But service providers to public authorities are only those under a direct contractual relationship, not those under a subcontractual relationship. So there are various kind of practical factors that are going to need to be worked out about who this in fact applies to if you're looking at the way that contracts take place and the way that services are actually delivered in this day and age. Next slide, please. So again, I'm in particular thinking about how this will impact upon the delivery of services. So it's about, are your contracts, do they currently include things to do with the insertion of a duty of candour and the need to be candid and frank, and the insertion of clauses into contracts about suppliers of public services when their health and safety of responsibilities? How does the public authority enforce against the service provider if there's then an inquiry? Now, plainly, the inquiry chair, whether it's statutory or non-statutory, or the coroner, can issue a compliance direction, but is there going to be a need for the public authority to in effect preempt that by having some kind of requirement that the service provider provides them with documents, records, information, requests? That's all going to have to be set out contractually. Foreign companies, multinationals, where officers may well reside abroad. As we know, a lot of the service provision is made by companies who have, are not necessarily UK based, and don't necessarily have the same responsibilities. And don't forget that this Act, at least in part, is going to have extraterritorial effect. Other things is, when you're procuring services, are you going to be asking them a standard pre-contract question? Are you being investigated under the Act? Have you ever been prosecuted under the Act? And again, I think there's going to be a need for a lot of training for service providers and contractors for those particular aspects. Next slide, please, Emily. Misleading the public. Now, this is a very broad general criminal offence. It's already been touched upon by some of the other speakers, but it reflects in a way an aspect of misconduct in public office as it currently exists, identifying that intentional recklessness. So there's going to be a high level of mens rea, but what is seriously improper has to be decided on an objective basis, taking account of all the facts. And so therefore, I think there is going to be a lot of case law which will come out in the criminal field about what is significant or repeated falsehoods, because its dishonesty includes not just falsehood but also concealment, and most importantly obfuscation. And obfuscation is the thing that happens most often, but the thing which is the most difficult, I would imagine, to prosecute. And also, what is one's expectation of a public authority and a public official? Now, I think a large amount of that is going to be obvious if you're talking about egregious things, but I can see a number of circumstances in which there's likely to be a lot of discussion about this, particularly as the offence of misconduct in public office wasn't used for years and years and years, and has only really in the past decade come back into vogue for anything other than people taking bribes at a local authority stage. So there's been some use of it, and I have had to have a look at the use of it in more creative contexts, but it is, as a common law offence, it's something which wasn't terribly well developed and for which there was some quite disparate and disjointed case law. Next slide, please. The other issue is, of course, the DPP has to give permission for these matters to be prosecuted. So I don't think that there is a risk, well, because on that basis, obviously, I think there is a reasonably small risk of private prosecutions, but I think there is a possibility of meretricious claims, as I call them, particularly by active citizens, if I put it like that. And also, I think there's going to be a real issue about what is a significant departure, what's going to be considered to be within the bounds of acceptable obfuscation and what's not, what's unacceptable obfuscation. I can well see there being a lot of dancing on the head of a pin as far as that's concerned. Next slide, please. There is also the Law Commission back in 2020 published a really interesting report that I would, if anybody has a spare afternoon or so, is really is where I've got all my information ever about misconduct in public office, which has been a common law offence that has gone on since time immemorial. But what the Law Commission recommended in 2020 is that there should be the abolition of the common law offence, and this bill does that, and in effect provides a statutory offence of misconduct in public office. And I will talk a little bit about that in a moment, but the main implication, I think, is going to be training on the Act, because the wide nature of who is a public official means that definitely this is going to cover a large number of people, and the broad nature of misconduct in public office, because misconduct in public office is going to be not just you getting a benefit, so not just you taking a bun, something which we all recognise and which is dealt with by things like bribery in any event, but also for a public officer to either obtain a benefit or cause someone else to suffer a detriment, which they know is a seriously improper act. So that's going to be financial gain or loss, protection or enhancement or damage to someone's reputation, or benefit or detriment of a physical or sexual nature. So, I mean, the case where I thought about misconduct in public office has been used when, for example, a bishop took advantage of various members of his flock to encourage them to engage in sexual activity with him. That was held to be a misconduct in public office. So you can see that there's a very wide nature of possibly poor and bad behaviour, which may well be covered by this, which isn't just the obvious things that you might think about. And in particular, I'm thinking about protection of or damage to a person's reputation. I'm just envisaging that in the context of the somewhat heated discourse and divisive and often rude discourse that people engage with each other, and how much that might be considered to be misconduct in public office. I mean, if it means that there's going to be a return to greater civility in the way that people speak to each other in public, well, that seems to me would be a good thing, but I'm not sure that that's necessarily what they're trying to get at. Could we turn to the next slide, please, Emily? So there's also another criminal offence, which is clause 13, which is the breach of duty to prevent death. So this, in effect, is an active bystander inaction test, I would suggest. So somebody can be convicted, and this is the most serious offence, as you can have up to 14 years in prison if you're convicted of this, commits an offence if, by virtue of their office, the person is under a duty to prevent or prevent the risk of another person suffering critical harm, which means either death or grievous bodily harm, and that person knows that, but they intentionally or recklessly cause or create a significant risk of causing another person to suffer critical harm, and the act falls below what could reasonably be expected. So the question is not necessarily whether or not somebody has actually died or suffered GBH, but whether there is a serious risk that they could have done so. And it seems to me that anyone that operates systems that could lead to death, well, that's anyone who works in a hospital, anyone who operates something in the health service, anybody who operates kind of health and safety type responsibilities or liabilities, a number of which could lead to death or serious bodily harm, police forces, the local authority, for example, in Grenfell, when you're constructing an office, constructing a building, the operation of a building, all of those means that you have to recognise that there will be, I mean, there are already mechanisms, for example, corporate manslaughter charges, which can be brought. But as I think we all know, they're exceptionally difficult. So I can see this as being a route into public officials being held to account far more frequently, not just if acts actually occur, but if there is a significant risk of causing people critical harm by, for example, having a building which is totally falling down, or having a set of housing standards potentially which are woefully below that which you would expect. So I can see that being an area of significant concern. Next slide, please. Oh, in fact, and so there are broad implications of this for all public office holders, including those who want to take voluntary roles. And of course, public body includes schools. So very many of us are or may have been governors of schools, so it will apply to us. Non-exec roles in public bodies, volunteering roles within public bodies, of which there are a number. And there will need to be some discussion about the way that, in particular, the criminal offences that I've spoken about may then apply. There'll have to be some discussion about what codes and training may largely it is a codification of what could possibly have happened anyway. But as with all codifications, one may well see a greater degree of prosecutorial zeal than there has been to date. And certainly there has been a view amongst very many people that there has been a relative absence of criminal accountability for people involved, even where there have been serious concerns raised against their honesty, candour, and their behaviour, which has led to people's deaths. I think, for example, of Grenfell. I think, for example, of my clients in the infected blood inquiry, who would have said that a number of people quite literally had blood on their hands. So we have a number of really interesting questions. We are nearly at 11:30, but we will go slightly over to try and answer them. I'm going to take them in the order that they've been come. So if all my fellow panelists can come online. So the first question that somebody's asked is, how does this bill impact FOI requests and requests under the Data Protection Act? Claudia, maybe do you want to take that?
Sure. I think the overall answer is probably relatively little. I think one of the really significant things about the FOIA and EIR and SAR and all the rest of it is that they are really quite well enforced and standalone statutory provisions that operate really quite separately to any rules either in statute or under the common law relating to disclosure, inquests and inquiries. So I don't think that it really adds anything to what already exists and what already compels public authorities to disclose information, except where one of the statutory exceptions already applies.
Okay. Does anybody else, Natasha, you had your hand up.
So no, I was just going to say I completely agree with everything Claudia said, but I do think that the addition of the duty of candour in public inquiries means that we have an interesting new addition to the kind of parallel regime. So if you get information from a FOI request that might otherwise come up in the public inquiry, and that information is different, that might set alarm bells ringing in the inquiry. And also, if you're the public authority, you really want to be thinking carefully to ensure joined up thinking across your
well I mean speaking as someone who once engaged in litigation where the information that the public body told people by way of FOI was significantly different to what they told people in the context of the litigation, yes, that's already an issue, but I think it will become even more of an issue. Second issue, again, I think this might be for Claudia, but more generally, Claudia, do you know how the Clause 2 duty, re-notifying inquiries if your acts might be relevant, and this is a number of questions that's been asked, is about how does the Act intersect with the right to avoid self-incrimination? So I think I have some views on that, and I think we probably all have some views on that, but passing first to Claudia.
I think this is a really interesting and probably not altogether straightforward question. I think one thing to note at the outset is that as it stands, my understanding of the bill is that it does not extend the duty of candour to criminal investigations. It is concerned mainly with public inquiries, statutory or non-statutory, and inquests. And public inquiries are statutorily barred from making any findings of civil and criminal liability. So to that extent, strictly speaking, if an inquiry is acting within the scope of its terms of reference and within the scope of its statutory powers, there ought not to be a restriction on the right or the freedom from self-incrimination. Equally, there are some other interesting factors to consider. We know that public inquiries and inquests can and indeed have served as a springboard for criminal investigations. Inquiries can ask the Attorney General to make undertakings that the material disclosed will not be used for criminal proceedings, but that is slightly separate. I think my honest answer at this point is I'm not entirely sure. There are some quite tightly, there are, as we've canvassed already, quite a lot of restrictions that are set out in the bill that should hopefully mitigate any risk of self-incrimination. But another question that which arises for me is, to what extent do these statutory provisions have the effect of overriding the common law rule against self-incrimination? We know that common law rules can be expressly overridden by Parliament. Does this bill do that? I'm not certain.
I mean, my view is that if they wanted to rule against the privilege against self-incrimination, that the best way to do that would be to have expressly say so within this bill. And so as this bill is about to go to the House of Lords, this would be an issue which I would imagine that the House of Lords will want to grapple with. And if they haven't, then if anybody's here who's responsible for amendments in the House of Lords, there are certain forms of statute which do expressly rule against the rule against self-incrimination. The one that I know best is Section 98 of the Children Act, which basically means that in care proceedings, you don't have the right to say, I'm not going to say anything when there's discussions, because the view is that it's more important to find out what happened in order to preserve the rights of the child. But there are also other circumstances, I think, in various forms of money laundering proceedings, various forms of tax proceedings, when you don't have the right to use self-incrimination. So it strikes me, and in order to avoid, I know the problems which have happened both in Grenfell and in the post office and in other matters where people have been reluctant to come along to give evidence because they are worried about being prosecuted. And if what we're really interested in is candour, then an obvious way to improve that is to say, right, there will be a general rule that nothing in these things can be used. So in other words, the Attorney General's undertaking, which currently happens if the inquiry chair asks and if the Attorney General then thinks it's a good idea, which is a negotiated process, could be put on a statutory footing. And in a way, the Inquiries Act tries to do that by saying there can't be a finding of criminal liability. But it would seem to me that if what they're trying to do is to try and encourage candour, one of the things you're going to need to do is, in effect, get rid of the right against self-incrimination. And I think you can do that in the context of public inquiries because of the fact that you're not finding a criminal offence. But I think you would need to do that expressly, and it is not done expressly at the moment. And I am assuming that that is a deliberate choice on the part of the draftsperson. Natasha?
I'm just coming really quickly on that because I think that's really interesting. And yeah, it'll be interesting to see how it plays out. Just from a kind of slightly more procedural perspective, I think there has been a report written by the Joint Committee on Human Rights, which was, I think, back from maybe March 2024. And I think the current kind of government response is that there will be consideration of, obviously, the human rights implications of the bill as it passes through. So it was really a kind of watch this space that obviously, at least the Article 6 element of the privilege against self-incrimination is going to be something that has to be kept under review as the bill progresses. And
because obviously, as we know, the right against self-incrimination is an Article 6. Is it right against Article 6? I think it is.
So I think it is exactly. So that's obviously the human rights element of it. But if we see that as two sides of the same coin,
I mean, there have been historically, there are carve outs, and I think the Children Act is probably the best and most widely used example in day-to-day practice, and it does work there, because quite often you will have care proceedings which take place before a criminal trial happens, because of the way that things work. So I think maybe looking at that and seeing how that has worked might be a way round offending breaching Article 6, or how that works in places. We've been asked about which parts of the Act apply to Scotland, Wales, and I'm assuming also Northern Ireland. The answer to that is they apply in as much as the underlying, well, it's a UK-wide Act, so all the clauses apply to the UK as a whole. If there are devolution issues under the Inquiries Act 2005, there are various things which only the Scottish or the Welsh or the Northern Irish ministers can deal with, and that's matters which they deal with generally. So, for example, you can have a UK-wide inquiry, for example, COVID, but you can also have a Welsh inquiry, a Scottish inquiry, and a Northern Irish inquiry, for example, about the health impacts, as we've seen. So, in as much as it follows the usual rule, in as much as the bill applies to the, as I see it, to the whole of the UK, so the public authorities, the bits I've been mentioning about apply to everywhere, but there are specific bits to do with when public inquiries apply. There's slightly different coronial systems in Scotland. There are different forms of investigations of accidents in Scotland, but the bill specifically says they apply to where the law is different, to the bits where the law is different. So I think the devolution issues probably won't be that different. Chris may well have a different answer, though.
Yeah, I just wanted to say that the devolution issues are dealt with at section 27 to 30 of the Inquiries Act 2005.
Yeah.
Essentially, you can't request evidence in relation to another devolved jurisdiction if it's just an inquiry that deals with one country.
And also it enables there to be various forms of consent that are needed before you set investigations up, which might impact on more than one jurisdiction, or which only impact one jurisdiction. They should be set up by the Senedd, for example, or by the Scottish Government if it's just to do with Scottish matters, which is why you have sort of different inquiries running about similar topics in different jurisdictions, which can sometimes be frustrating for campaigners. Right. Somebody's asked a question about statements responding to specific questions at inquests, saying, well, we're not going to provide it now, we're going to provide it later. How far does this Act prevent people saying, well, I'm not going to answer this now, but I will answer it at the inquest? I think this is more of an inquest question than a public inquiry question. Natasha, I think, wanted to answer that.
Sure. Yeah, I mean, hard to answer specifically, but I just draw your attention to clause 2(6), which currently provides that in complying with obligations under this section, so in complying with the duties that Claudia outlined, a public authority or official must act, and then A is expeditiously. So I think while the Act doesn't define a specific time frame in which the duty of candour needs to be complied with, I think if you're in the context that the questioner describes, where you're trying to get evidence and it's being pushed back for a live hearing, citing that provision, if it becomes law, would be quite a helpful way of encouraging a quicker response.
Claudia.
Yeah, I'd also add that it does seem incredibly common in a lot of inquests for dates to be pushed back on several occasions owing to issues with various bodies not meeting their disclosure obligations, and coroners therefore exercising their discretion to push dates back, which comes at enormous frustration for the families of bereaved, and often results in the evidence being heard being of worse quality owing to the passage of time. I think there is hope that the duty not only to act with candour and to assist, but the requirement of acting expeditiously makes bodies engaging with inquests take those timeframes more seriously.
Yes. Somebody else has asked whether or not this thinks that inquiries may become more streamlined. because you end up with masses of disclosure, which costs a lot of money to process. I have to be honest with you and say my instinctive view is that what will happen, because people will be so frightened about not providing the relevant documents and therefore being seen as obfuscatory, is there will be more document dumping than happens at the moment. So I think an unintended consequence of this means that public inquiries and inquests will go on for longer, because everyone will be really worried. Everyone will go through every single filing cabinet. Well, hopefully they will. I mean, this is what they should do. But that therefore means that people will send too much rather than too little. Certainly that would be the advice I would give to public authorities, certainly at the moment. Anybody else have any different views? Chris?
I think it's very interesting. I mean, the example that I gave earlier was the post office inquiry, where the post office were very, very late in complying with disclosure requests, and that held up the progress of the inquiry. So if you have an organisation that is not able to access its data because it's in different places, for example, and hasn't quite appreciated the scale of the problem, a positive effect is that the disclosure will arrive more quickly, so you won't have delays and you won't have to have hearings asking people, why you haven't complied. So although I think Fiona's absolutely spot on that people will dump more documents, it will have a positive effect in that you won't have an inquiry being frustrated by inadequacies in disclosure, because people will be much more alive to the issue.
I mean, my issue, however, is the inadequacies of disclosure are usually caused because of the inadequacies of the record keeping in the first place. And I have yet to find a public body anywhere which has adequate record keeping facilities. And I'm not saying that. I'm saying that generally. I'm not saying that about any of my individual clients who I have ever had. One of the difficulties, I think, with the arrival of the electronic age is it's simply impossible, it seems to me, to keep track effectively of everybody's data over the period of time you might be looking at in the context of some inquiries. I think it's quite straightforward if you're looking at an incident which happened on a day. But for example, if you think about the COVID inquiry, you think about, I mean, we're talking hundreds of millions of documents that have been produced. So I think one of the difficulties is that there may always be a smoking gun, but the difficulty that we have in this day and age, unlike paper files, where people had a file, people put things in piece of paper, people didn't tend to write pieces of paper unless they needed them, is just finding the stuff which is relevant can be an industry in and of itself. And I think we need to think really carefully about how we use these new powers under the bill, which I really welcome and I think are like a brilliant idea, but how we look at that in the context of practicability in respect of data and disclosure. Right, next question. If a public official is responsible for an organisation's response and is also potentially criminal culpable, might not there be a conflict of interest? In that case, should others within the organisation become more responsible for the response? Chris?
Yeah, that is an interesting question, and a very good question. The bill identifies the person who is considered to be responsible. If the person who the direction is aimed at isn't responsible, then they can say, well, don't direct me, direct my colleague. I think it's difficult to see where there would be a conflict of interest, because if that individual is responsible, then that individual is accountable. And part of the problem in many public inquiries is that core participants want to know who knew what, when, and where. They want accountability, and it's very easy, I think, for institutions. This is talking from the complainant side, to take a corporate responsibility approach. So no one knows who's responsible. And I think having someone, an individual named, an individual who is potentially liable, will increase accountability. So I think that's what that is driven at. I'm not necessarily sure that there will be an individual can say, well, I'm now the person who's in charge, and I'm now looking at records of what happened, 20 years ago. It's nothing to do with me individually. That's not necessarily a conflict, because all that person is doing is being candid. So I'm not sure there will be a conflict there.
I mean, I think this already exists, which is why one of the purposes of us as legal advisors is to say, you may well be in the frame here. Is it sensible that you're the one that gives us instructions, because you might be a bit too close to the events in question? I mean, you don't necessarily want the person who's giving you instructions about what documents you're going to be the person who is alleged to have burnt the documents. You might want to say somebody else needs to be in charge of that. But I don't think the Act changes that. I think the Act might make people think about it a bit more, but I don't actually think the Act changes that. I think that's something that you would already have been looking at or already thinking about. I'm conscious of the time. We've gone 15 minutes over. We still, however, have 178 participants. So I think maybe if we try and very quickly answer a couple more of the questions, but we might not be able to answer all of them. So somebody's asked how much Clause 8 might extend the duties created by the Act to the Ombudsman Service. Could the duty to comply with the Code of Conduct extend to Ombudsman Service that are set up under statute? Well, the answer is yes. They're public authorities, they're public bodies. They would have to apply by a Code of Conduct. In fact, the Parliamentary Ombudsman and Local Government Ombudsman would already have to apply all those public bodies already have to apply with the Nolan principles, and all the Code of Practice does is really enshrine that in statute, which is not currently at the moment. But I mean, some of them, like if you work for the Parliamentary and Health Service Ombudsman, you're a civil servant, you're a central government civil servant, and therefore you're bound by the Civil Service Code in any event. But yes, I think that means any kind of publicly run ombudsman services, the Nolan principles apply to them, but they always have. How does the panel think the contractual requirements may interact with the ongoing debate on AI when it's difficult to understand what's going on behind an algorithm? Now, I'm not going to answer that question because, I can barely understand what algorithms are, let alone anybody want to hazard an answer?
I could, if no one else wants.
Yes.
I think it's very difficult. AI is going to change, pretty much most of the way that information is, looked at. I think what's going to happen is you are going to get IT people heavily involved in terms of giving evidence, and maybe a senior IT director will be the person who has to sort of explain how AI has impacted on the disclosure or the ability to disclose. It's a very good question, and like very good questions often are, it's difficult to find an exact answer. But I do think certainly more technical witnesses is a way forward.
Okay. Somebody's asked, how will public authorities know whether proactive notification duty applies without a chair or investigator requesting information? Will there be a monitoring duty on public authorities, and how can this be proportionate? We are worried we'll miss what we should be aware of. Claudia.
I think this is a really important question, particularly in view of the fact that, I'm a public inquiry practitioner, and I can't keep track of all the public inquiries that are going on. A new one pops up every week, right? I expect this is something that is going to have to be, that further guidance is going to be required on. But also, I think it's important to bear in mind that in practice, if you are a public authority, that is likely to face criticism from a public inquiry or an inquest, you will probably be told about it or otherwise engaged in advance of like the inquiry or inquest coming into being, right? I think it's practically unlikely that you're going to find yourself completely unaware that a public inquiry has been convened in order to investigate your actions or inactions, and that you'll therefore kind of fall foul from that respect. I would say that, you know, having strong internal processes for the purposes of kind of disseminating information between things like policy, legal, kind of safeguarding teams, and that if you're a local authority, for example, kind of strong channels of internal communication so that reputational risks are understood where there may be legal risks attached to them as well. Equally, as Fiona has said, strong internal processes and systems for data retention is only going to help with that. I would say, apart from that, though, I think generally systems of kind of CPD and training within your kind of internal teams to ensure that where any risks in the form of, you know, inquiries, investigations, inquests, or whatever are spotted, they are suitably escalated and dealt with. It's probably a good place to start. Generally, I wouldn't be worried too much about being caught out completely, but that doesn't lessen the importance of building in appropriate systems and protocols for keeping things on your risk register.
I mean, what I would say is most of the time now, so this is in advance of the act coming in, if a public inquiry starts and they're likely or there's a possibility they'll ask you for information, usually the minister issues a notice. So, for example, in the independent inquiry into child sexual abuse, the Secretary of State for Education issued a notice to all local authorities saying, do not get rid of any documents. And fundamentally, what the compliance direction can do is for the chair of the inquiry, including non-statutory inquiries, to be able to in effect say that. So I would envisage in any inquiry where you're likely, or inquest where you're likely to have to do that, and the coroner can do that as well, to say, please don't throw anything away, or please start collating that information. So I think you know, I mean, I think it's slightly different. Where you are likely to run into a proactive notification is once that direction's been done. If you then find a load of things in a shed, you are going to have to say, we found a load of things in a shed and we're sorry that we haven't found the loads of things in the shed before now. It seems to me. Right.
I'm just going to quickly add into that I think actually, again, remembering how parallel this duty is to how it would operate in judicial review is important. And in the context of judicial review, TSOLs as well as had guidance that was intended to help government departments and public authorities comply with the duty in that context. I'd be really surprised if similar guidance isn't issued. So hopefully public authorities will be able to look at something from central government to help them answer these questions.
Right. That is really helpful. I don't think we can answer any more questions, but obviously I think this has definitely provoked a lot of discussion, and it may well be that we're prompted to do a follow-up, or maybe one of us will be prompted to write an article based upon the questions that people have asked us, so that we can think about these issues more generally. Thank you so much, all of you, for coming. We really appreciate you taking the time to listen to us. We hope it's been useful. The slides will be circulated shortly after the end of this recording, and as will a copy of the recording in and of itself. And we look forward to welcoming you at future landmark events. Thank you very much.